Good evening, friends. Amongst us, we have Mr. V.Meenakshisundaram, an advocate from Madurai bench of Madras High Court. And today's session is preliminary issues in civil suit. As a student of law and as a lawyer or a judge, we know that issues are just like the rules of the game which we build up so that we know how the game starts. Just like in cricket, we have duck list system, etc. Similarly, the issues decides the parameters, how you frame your evidence, etc. And preliminary issues within the issues, if you examine under Order 14, you will find these all aspects. And Mr. Meenakshi has already done a session with us that was well received. We had again requested him to share his knowledge. Since he has a forte in the civil law, and he was kind enough to accept our request. Over to you, Meenakshi.
Thank you. Thank you for your nice words about me. And good evening to one and all my brothers and sisters of this legal fraternity. Now, today's topic for our discussion is preliminary issues in civil suit. Before going into this discussion into this core topic, I may permitted to take 5 minutes why I have chosen this topic today for a discussion in this platform. First, I believe filing a civil suit and conducting a civil suit is a very serious business. And in the recent scenario in our society, these civil suits are not taken as a very serious business. As in my humble opinion, these civil suits are filed as in a routine manner to deviate from some other criminal prosecution or some other main proceedings which are pending before different authorities. And civil suits are also filed not in a comprehensive manner. And suits are filed something like drafting a plaint is now not a serious business. It is something like drafting a petition to an authority. And in such a manner, civil suits are now flooded in the civil courts. And these suits are not to the benefit of the litigant. And that is how the various other applications are coming after trial. And in such scenario, I personally felt that this is a topic which has to be discussed very seriously. And I have chosen this topic for discussion and don't think this is a session of a lecture series. And as when an invitation was given by Vikas, my brother, I said that it will not be like a lecture session. Please give the liberty to have a discussion on this topic. And that is how I take this liberty and I start this discussion. Now let us go into the topic that preliminary issues in civil suit. These preliminary issues in civil suit, as my brother said, issues are something like settlement of issues in a civil suit is something like framing of a charge in a criminal proceedings. And in a common man language, I can say that these are all the boundary lines within which we can play the game. Without knowing this boundary line, whatever the performance you perform, it will not give a result. It will not be in a correct platform or in a correct channel. And that is how issues becomes much important in civil litigation. These issues, if you want to touch the discussion on issues and more particularly preliminary issues, and what is the difference between the power with the court to deal with the plaintiff before the defendant enters into a civil litigation, civil suit, and after the appearance of the defendants, what is the role to have a suit to be disposed on a preliminary issues, are all there is a thin border line to differentiate these stages. That is how this topic becomes more important as on today. Now, before going to this, let me take some important provisions in CPC which deals with jurisdiction of the civil court, how a suit can be tried, and how a defendant has to raise objections regarding jurisdiction, and that objection, how it can be dealt by a civil court. These are all some important provisions which we have to discuss before going into a discussion for framing of a preliminary issue under Order 14 and with other provisions of law, for which I may first go to Section 9 of CPC. What it says, all suits of a civil nature is maintainable and can be tried in a competent civil court unless it is impolitely and expressly barred under any law. So all suits are maintainable. And the only restriction given is it has to be expressly or impolitely barred. And if you take next important provision is Section 21 of CPC. If it says that what is Section 21 of CPC is objections to jurisdiction. It starts with the Section 21 of CPC says objections to jurisdiction. No objection as to place of suing shall be allowed by any appellate court or revisional court unless such objection was taken in the court of the first instance at the earliest possible opportunity. Therefore, it is the duty of the defendant to take such objections to the jurisdiction of the court to try the suit at the earliest point, and that too only before the trial. This is the basic thing which we have to note, because whenever you take objections before, after trial, or before the appellate court or before the revisional court, such objections are not entertainable in view of Section 21. Therefore, objections regarding jurisdictions. At this point of time, I want to share with you all that one of a practical experience which I learned. Whenever a plaint is filed and whenever a defendant appearance is given to our office, the first lesson given to the juniors is file wakalat, directly go to the registry, check the plaint, original plaint, and the annexed documents, and please look into the returns and the clarificative explanation given by the plaintiff counsel at the time of numbering, because all these things are very important, and this will be very helpful to take these objections regarding jurisdiction, cause of action, and pecuniary jurisdiction and all type of technical objections to cut short the trial. And that is how we are trained, that you must see the original plaint and the returns. Because why I insist this is, a plaintiff can dealt with the court to get his plaint numbered. He must satisfy the court, and court must satisfy with the plaint averments. And the power under RS7 Rule 11 is different from raising a preliminary issue in the suit. See, always the next important provision which I am going to discuss with you all is RS7 Rule 10 and RS7 Rule 11. When these provisions are there, even though the rule says that it can be filed at any stage of proceedings, the boundary to discuss those provisions or to adjudicate those provisions is only the plaint and the plaint documents. So if the plaint and the plaint documents are looked into, and if the court comes to the conclusion that it is entertainable within the jurisdiction of this court and there is a cause of action, then the RS7 Rule 11 and RS7 Rule 10 cannot be exercised by the civil court. At that stage, it is only the plaint and the plaint documents, and it is only between the court and the pleadings in the plaint. But these preliminary issues get importance. Comes the next hurdle for the plaintiff, that by the pleadings of the defendants, we come out with the different pleadings to say or to assist the court, this plaint is not entertainable before this forum because of these reasons, which are not stated in the plaint, we are bringing to the knowledge of the court. For example, immediately I can say that a pecuniary jurisdiction of the court, a valuation of a suit property, it is only as per the plaint averments and as per the market value or the value determined by the plaintiff and satisfy the court to get the plaint number. And if the defendant comes with an objection to this jurisdiction on pecuniary limits, with the pleadings that this suit property is not correctly valued, and these are all the materials to show the valuation the client is wrong, then the objection to the jurisdiction as per 21 raised, that leads to a framing of an issue which can be decided or which can be decided with all other issues. That is the discussion which we are going to make. Therefore, the thin line of difference between Order 7, Rule 10 and the power of the court under Order 7, Rule 11, which can be exercised at any point of time, is limited to the pleadings and the documents in the plaint, annexed with the plaint. But if the materials and the prima facie evidence are given in the objections or in the pleadings of the defendant, then he can raise it at a preliminary issue and to decide the pleadings in the plaint are not correct. We are assisting the court with some other materials to say that valuation is wrong. Then it becomes an issue which can be tried as a preliminary issue. Next important provision which has to be discussed is Order 8 Rule 2, which specifically says the facts which are to be refuted in the written state, which has to be refuted. And we always peruse all the written statement, at least speaking for our state. We have a normal paragraphs in all our written statement to say the plaint is not drafted and the limitation is not correctly calculated and the valuation has not been done. And we reserve our right to take those issues in by way of a separate applications. These are all mostly in usual plaints. When we attack the plaint in our written statement, these averments are there, but you have to make it in detail. These are all not mechanical averments to be there in the written statement. It has to be made very clearly what are all the points to be refuted, and it must be made very clearly to the objections regarding to the jurisdiction, limitation, cause of action and everything. If such objections are raised as contemplated under section 21 of CPC, that will give you the route to raise it as a preliminary issue under Order 14. Unless those averments are not there in your pleadings to this plaint, objecting the plaint, the way of the right of taking a preliminary objections or to right to frame a preliminary issue is not at all possible in a civil court proceedings in a civil suit. Therefore, refuting under Order 8 Rule 2 is also an important provision to be taken note of. And next we come to a major, more important provision is Order 14. Order 14 Rule 1 says particularly deals with settlement of issues. Issues whenever arise between the parties, the settlement of issues are to be the main point, and I can say it is the first point, very important point in the course of trial. And originally the settlement of issues are by way of an adjudication of preliminarily hearing both sides' counsel and perusing the pleadings of the parties. And I insist that whenever a suit comes to a stage of Order 14 for a settlement of issues, it is better to have a small discussion or an argument on the settlement of issues. Nowadays, I believe the settlement of issues are taken as a normal course of business, and it was even in a suit for declaration or in a suit for specific performance, we are able to see that the necessary issues are not framed. Even in a specific performance suit, the mandate under 16C is not framed as an issue. We are seeing many judgments of Honorable Supreme Court on this point. The specific performance was decided without framing an issue on the mandate of 16C. And in a declaration suit or in a partition suit, there is even in a partition suit, the first issue has to be whether what is the nature of the property and what is the availability of the property, whether the property is available. These are all the important issues which has to be framed. Even in a partition suit, when a will is made as a defense in a written statement, I'm able to say the issues regarding the will was framed as a first issue. Before the will was framed as a first issue, there must be a issue regarding the nature of the property. These are all some important issues which are missing down in the present scenario in a civil suit. Therefore, under Order 14, it is my humble opinion always the pleadings of the parties are also very important, and hearing them on a very summary hearing of the parties or their pleaders are very much important to decide the important settlement of issues, because before 14 there are provisions in CPC to cull out the admissions out of pleadings, and there are provisions to pass judgment and degree on the basis of admissions of the parties. Therefore, when these things are there in provisions or at 12, Rule 6 and other things are there, the importance of hearing parties at the time of settlement of issues, because after Order 7, Rule 11, after the power under Order 7, Rule 10, we are traveling to an extent of pleadings, and after pleadings, we are traveling to an extent of the facts or the point which are all not admitted, which are now in issues to be decided, and which are all admitted can be decided under Order 12, Rule 6 and other things. And only thereafter we come for a stage that these are all the issues for which we can get into the trial. And at that stage, hearing of parties is very much important, at least in a summary manner. And next, how the issues can be framed and what type of issues can be framed. Always, we are having a basic lesson that pleadings of the parties will have only the narration of facts, and it will have the right which they have accrued from the factual aspect, and they will say the reference to their right out of that fact. Then when these pleadings of the parties are before the court, there can be two types of issues as stated in Order 14, Rule 2. And as of now, Order 14, Rule 2, there are this Order 14, Rule 2, which now we are dealing with, has undergone a change. And before an amendment, this Order 14, Rule 2 is on with some other wordings. I can say that Order 14, Rule 2 before amendment gives a power to the court to frame issues and take out the issue of law first and decide it by hearing the parties with available, by giving them an opportunity to lead evidence and decide that issue of law first, and postpone the issues on other aspects to be decided later. But if you now see the present Order 14, Rule 2, it is very, very specific that court to pronounce judgment on all issues. See, this Order 14, Rule 2, if you all see with Order 20, Rule 5, Order 20, Rule 5, and Order 14, Rule 2, these two provisions are to be, it must have and has to be read side by side. Order 20, Rule 5 says the court has to state its decision on each issue. And Order 14, Rule 2 said it specifically have a wording court to pronounce judgment on all issues. Therefore, after amendment, it is mandate for the court, civil court, to decide and to pronounce judgment or pronounce its verdict on all issues. And the only exception is given, notwithstanding that the case may be disposed of on a preliminary issue, the court shall, subject to the provisions of Supreme Rule 2, pronounce judgment on all issues. Therefore, the only exception is the preliminary issues. And it has stated that what are all the preliminary issues in subclass 2 of Order 14, Rule 2, where issues both of law and of fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first if the issues related to, the wordings are very clear, jurisdiction of the court or a bar to the suit created by any law for the time being in force, and for that purpose may, if it thinks fit, postpone the settlement of the other issues until after that issues has been determined. Therefore, now Order 14 Rule 2 is very specific. There are two types of issues, that is issues of law and issues of on facts. And the issue of law must be related to, which can be tried as a preliminary issue, can be related to jurisdiction of the court or a bar to a suit created by any law for the time being in force. Then the next point for discussion comes, if you raise a issue of law related to a jurisdiction of the court. See, these two preliminary issues, bar created by any law for a time being in force, or an objection related to the jurisdiction of the court. See, these two becomes a preliminary issue, which is also a part of a ground in Order 7 Rule 11. When the court decides an objection of a similar nature under Order 7 Rule 11, it will not travel beyond the plight. But the difference is, if an issue of law is raised as a preliminary issue under Order 14 Rule 2 subclass 2 regarding jurisdiction and a bar created by law, the evaluation is something more. What is that evaluation? It is by the assistance of the defendant in the pleadings and the material supplied by the defendant to say the pleading stated in the plaint is not enough to decide whether the court is having a jurisdiction. And the pleadings in the plaint is not enough to come to a conclusion it is barred under any law. This is how the difference between the same ground stated in Order 7 Rule 11 to reject a plaint at any stage and an issue which was now raised at the settlement of issues to try it as a preliminary issue by the pleadings or assistance of the defendant. Therefore, the issue which can be decided as a preliminary issue is only an issue on law. And that issue of law can be decided more particularly with regards to the jurisdiction of the court or to a bar to a suit created by any law for time in force. Now let us discuss what is an objection to a jurisdiction of the court. Jurisdiction of the court can be raised either to a territorial jurisdiction or to a pecuniary jurisdiction. If it is to a pecuniary jurisdiction, then it comes to a valuation of the suit property and the payment of court fee. If it is on a territorial jurisdiction, then it is all about the territorial jurisdiction, where the property is situated and how the suit can be tried, whether it is within the territorial jurisdiction. According to me, objections regarding territorial jurisdictions can be decided very easily. Only very in the rarest case, it becomes a point to be decided with the assistance of a defendant. But otherwise, territorial jurisdiction of a court to try a suit can be very well decided with the plaint pleadings and the description of property there in the plaint. But if it comes to a pecuniary jurisdiction, then it has to be decided. It cannot be decided only on the plaint. Even the plaint cannot help the court to come to a conclusion whether it is a correct valuation and whether it is coming within the pecuniary jurisdiction of that civil court. If that is raised as an objection by the defendant, and that becomes an issue of law regarding an objection regarding the jurisdiction of the court, then that can be raised as a preliminary issue in the civil suit. Then when it can be raised? It has to be raised in the written statement at the earliest point of time, and that has to be addressed to the court to be tried as a preliminary issue before the evidence starts. If the issues are framed and parties are allowed to pour into the evidence into the civil court, the right of framing a preliminary issue at the instance of defendant is no longer in existence. Therefore, the right given to a defendant to raise a jurisdictional issue regarding the jurisdiction of the court to try this suit has to be raised are addressed to the court before the evidence starts in the civil suit. And that is more important for this discussion. And the next point is how a jurisdiction, objections regarding the jurisdiction of the court can become an issue of law, whether that issue of law is completely purely an issue of law, or it have an impact of an issue of fact or adjudication of some factual aspect, to come to a conclusion that the suit is not properly valued and therefore it is out of jurisdiction. In that point of time, the thumb rule is, if an objection is raised as to the jurisdiction of the court and the defendant is by way of materials with pleadings assisting the court, which does not need any roving inquiry, or it needs only a summary inquiry to come to a conclusion that it is a suit out of pecuniary jurisdiction, then it has to be raised as a preliminary issue and it has to be decided only as a preliminary issue under Order 14 Rule 2. If it is the bar under any law for the time being in force, for example, nowadays there are many suits are filed to stop bank proceedings under many special enactment and to stop many other revenue proceedings. And with the legal mind, the plaints are drafted in such a way that by reading the plaint, the court cannot come to an immediate conclusion that it is a suit with a cause of action with these specific priors are barred under any law. In such point of time, if that is raised as an objection in the written statement and there is a petition filed to try that objection as a preliminary issue, then that has to be tried as a preliminary issue. Now, there may be some doubts arising. Barred under law is also a ground to be rejecting a plaint which can be raised at any point of time. But the same thing was also given as a ground under Order 14 Rule 2, and it has to be raised before the evidence comes to the court, and it has to be raised at the earliest point of time, and it has to be raised as a preliminary issue, and that objection also has to be raised before the evidence starts. And what is the difference between such things? One power was given to the court to reject on the same point at any stage, and other ground is given, the same ground was given in another provision to try it only as a preliminary issue, and there is a point of time which mandates the defendants to raise only up to that point of time he can raise such issues. The answer is again comes to the very simple point that there you can reject the plaint again there is some problems.
Yeah, you can start.
Yes. Yes. We are at the point of discussion that what is the difference between a bar created by law under Order 7 Rule 11 to reject the plaint at any stage of the proceedings and the duty of a defendant to raise it as a preliminary issue under Order 14 Rule 2. As we discussed some minutes back, the rule governing Order 7 Rule 11 to reject a plaint as it is barred under any law must be born out of the pleadings in the plaint itself. But if the materials are supplied by the defendant to assist the court to an extent that by reading the plaint you cannot come to a correct conclusion whether it is barred under any law. But if you have an assistance of the defendant pleadings and the material supplied, then you can come to a conclusion that this suit is barred under the law for the time. This is the law of special enactment which bars the suit, and therefore this can be decided on this preliminary issue. Next point for discussion always comes to to all our mind is why such a right was given to a defendant to raise all this important factual aspect as a preliminary issue. It may be an answer to my first discussion with you on that point, that many suits are now filed, and there is an opinion among our society that if we go to a civil court and if you file a civil suit, the result will be the fruits of the degree, or the result in the civil suit will be seen only by my next generation. This is the normal opinion in our society regarding the civil litigation, but it is not true. If you look into CPC, the civil litigations are decided at many stages. And that is why I started my discussion class with you all with the word that conducting or drafting a plaint and conducting a civil suit is a very serious business. And as we discussed earlier, there are many stages, there are many check and balances when a plaint enters into a court. And the first check and balance is the Order 7 Rule 10 and Order 7 Rule 11. Next stage comes is when the defendant enters, he gives one side of the side exposed by the plaintiff in the plaint as having a different scenario when there is a pleadings of the defendant. And if it comes particularly to an issue of law, as stated in Order 14 Rule 2, then it is the mandate of this court to decide those issues as a preliminary issue, to give a quietus to that litigation and not prolong the trial or drag on the parties to a complete trial. And such right was given to a defendant to have a disposal of the suit. At a second preliminary stage, I can say that at this stage, if the defendant convinces the civil court that it is a suit which has to be disposed of on these preliminary points, and I need not go to the entire trial process, he can raise those issues, and such a right was given under Order 14, Rule 2, and the subclause 2 specifically says the preliminary issues are more particularly on issue of law, and that issue of law is particularly on the aspect of jurisdiction and a bar created by a law for the time being in force. And these two things, when it comes to jurisdiction, it is also very important to take to the valuation of the suit and the payment of court fee. Under the Court Fee Act, there is also another provision, important provision, that is Section 12 of the Court Fee Act, which gives a similar statutory right to a defendant to raise an objection regarding valuation of the suit and the court fee paid thereon. And that right is completely, or it is directly linked with the objection regarding the jurisdiction to the court. See, if a defendant raises an objection and file an application under Section 12 of the Court Fee Act, that suit is not properly valued, and the court fee paid thereon is not under the correct charging sections, the consequences are two types. If the valuation is found to be wrong in an application filed under Section 12 of Court Fees Act by the defendant, then the plaint may go out of the court. If you find that the plaint is not correctly valued and it is undervalued, and the correct valuation is something else, the correct valuation may boost the pecuniary jurisdiction of that court, and that may result in either rejection or return of plaint to be presented in a proper form. And that is how Section 12 has to be read along with the right of the defendant given under Order 14, Rule 2. And particularly, there is an occasion, if an application is filed under Order 14, whether the court is having a power to say, under Order 14, Rule 2, if an objection is raised by the defendant in the teeth of Section 12, whether there is a power given to the court to say that this issue regarding jurisdiction on the point of undervaluation, even though it is an issue of law, to decide that it needs some issues of fact to be decided, therefore it can be postponed and it can be decided with all other issues. Whether such powers are vested with civil court, there is an issue raised. And it was referred to Honorable Division Bench of our High Court, Madras High Court. And it is a famous judgment, even now holds the field. S.N.S. Sukumaran versus C. Tangamuttu, reported in 2012 5 CTC 705. And it is a particular occasion where the conflict between Section 12 of Tamil Nadu Court Fees Act, Suit Valuation and Court Fees Act, and the power of the court to accept the same, whether under the preliminary issue or postpone that issue to be tried along with that issue under Order 14, it was raised and it was decided that the reference was answered if an objection was raised under a statute which get the precedent assent, that is the Tamil Nadu Court Fees and Suit Valuation Act, it will prevail over the procedures contemplated under Order 14. And it is a valuable right given to the defendant to avoid frivolous suit with an incorrect valuation. And that right was given priority to the right or a power given under Order 14. And if subject objections are raised by the defendant by way of an application under Section 12 of the Court Fees Act, the bench, Honorable Division Bench, has ruled that it has to be decided then and there, and it is an issue which cannot be postponed in the teeth of some powers granted under Order 14. And that has to be decided as the first issue in the suit. And there can be an evidence, not a roaring inquiry, that there can be a material supplied by the defendants to the assistance of the court, and there can be some evidence let in to decide the objections regarding the valuation, and the charging court fee section is not correct. And why such power was given under the Section 12 to the 12 of the Court Fee Act is the consequences also stated in the very same section. If you come to a conclusion that the suit is not properly valued and the proper valuation is completely a different thing, the plaintiff may go out of the court. And if it is in the district court on the original side, and there may not be much problem, but if it is in other two forums, that is Honorable Subcourt or before the Municipal Court, this objections becomes very vital point, and it can lead to a rejection or a return of plaint. And that is how, and this judgment even holds the field, and it is very important judgments regarding the conflict between Section 12 of the Court Fees Act and the power grant given under Order 14. And the next question or doubt arises is that whether all issue of law regarding jurisdiction or bar of suit under any law can be decided by the pleadings of the parties or with a summary inquiry, or whether this issue of law needs, if it needs some evidence, whether it can come within the definition of an issue of law which can be tried as a preliminary issue. Then the answer is immediately given by the Honorable Supreme Court in a recent judgment. Before that, a recent judgment is Saranpal Kaur Anand versus Pradhamun Singh and others, reported in 2022 8 SCC 401. Before going to these citations, it is also, I think it is also more important to have a discussion whether all objections regarding jurisdiction can be decided as a preliminary issue without any roaring inquiry, or whether you can say that any bar created by a law can be decided as a preliminary issue as it is an issue of law. For example, let us take the second point, a bar created by law. As I said, if it is a civil court jurisdiction is hosted in many special enactments, and for the business transacted under that enactment, completely the power of those authorities under that enactment and orders passed under that special enactment cannot be challenged and cannot be a part and parcel of a civil suit. But that bar created by law is also needs some inquiry when it's a bar created by some procedural laws. For example, principles of res judicata, order 2, rule 2. These are two examples I can give immediately to say this order 2, rule 2 is also a bar created by CPC. Principles of res judicata is also a bar created by CPC. But to decide these types of bar of suits created by law, we need some inquiry, some roaring inquiry with evidences. For example, if you want to decide section 11 principles barred by res judicata, there are some important ingredients to be established which need evidences to be adduced by both parties. The plaintiff in the previous suit, who are all the parties, what are all the pleadings in the previous suit, what is the nature of the claim, what is the issue directly involved, and what is the decision between the parties. These are all the things to be adjudicated before deciding a fact that this plaintiff is barred by res judicata. The same thing is applicable to order 2, rule 2. And that is why. And another important example is bar created by Limitation Act. The suit is barred by limitation. This bar created by limitation is again, there are many judgments to say a question on a bar by a Limitation Act is always a question of fact, mixed question of fact and law. But in some cases, bar of limitation is very, very evident, even by reading the pleadings of the parties. In such cases, that can be decided as a preliminary issue. But the issues of law, even though it become an issue of law, as stated in order 14, rule 2, subclass 2 is to say the objections are with regard to jurisdiction or a bar created by law, even though it looks like an issue of law, which can be raised as a preliminary issue. If the court feels to decide that issue of law, there are some issues of facts to be decided, and that issue of facts will lead to this decision on issue of law, then such issues need not be decided and it can be postponed to be decided in the trial. That is the rule which was there in this Saranpal Kaur Anand case reported in 2022 8 SCC 401, and the issue involved in that judgment is, that case is, and there is an objection related to a limitation aspect. And the limitation aspect was raised as a preliminary issue. And court felt that this is an issue which can be decided only after deciding with the pleadings and evidence of the parties, which needs more adjudication. And always when it comes to a point of limitation as a bar to a suit, it is always better, unless it is very evident from the pleadings of parties, it is always decided to be a mixed question of fact and law, and it has to be postponed to the trial. And even as I said, there are recent judgments which specifically says, even for exercising the power under Order 7, Rule 11 on the aspect, the issue regarding bar under Order 2, Rule 2, Order 7, Rule 11 to say that it is a suit barred under law, all these things, when we need some adjudicating process, when we need the parties to lead some evidence to bring it to the knowledge of the court, and there are some adjudication to look into it, then it cannot be decided as a preliminary issue in the suit to say that it is an issue of law. There are judgments to this effect. I will quote, and another judgment on this aspect is AR 2019 Supreme Court 5125. Nusli Nivilia and Ivory Properties and Others versus Ivory Properties and Others, reported in AR 2019 Supreme Court 5125. It have a detailed, this judgment, 2019 judgment, there is a detailed discussion how an objection regarding a bar under law or a jurisdiction of the court at the first point, it may look like an issue of law alone. But when it needs some inquiry to be decided, then it cannot be considered to be a pure issue of law, and it will not come within the purview of Order 14 Rule 2. This is also a very important case which is on this aspect. Therefore, the main aspect is the jurisdictional issue and a bar created by law is an issue, must be an issue of law, and that has to be raised before the evidence starts, and the defendant can supply a prima facie evidence with pleadings to assist the court apart from the pleadings in the plaint to say that this issue need not have a roving inquiry. With this simplest evidence on record and with the assistance of defendant's pleadings, it can be decided as a preliminary issue. Only on these occasions, the Order 14 Rule 2 subclass 2 comes into effect to say that a suit can be decided on a preliminary issue. More particularly, always the Order 14 Rule 2 scope is becoming an issue whether the court can frame all issues and take the issue of law alone first and decide it, or when an application is filed by a defendant of such nature to have that it is a bar to a suit or there is a jurisdictional error, whether the court is having a power to frame that issue as an issue of law. This aspect, the power of Order 14 Rule 2 was completely discussed in Foreshore Corporation Housing Society Limited versus Praveen Desai, reported in 2015, 6 SCC 412. This is a case law which completely discussed the scope of Order 14 Rule 2 of CPC both before and after amendment. And this is one of the important case law on this aspect. Next important case law, as we discussed earlier, what is the point to be which can be discussed as a preliminary issue is also another important case law on this aspect is AR 2006 Supreme Court 3672, Ramesh Desai and others versus Bipin Mehta and others. This is a case law which discussed on an objection by a defendant, the court can frame the preliminary issues alone and take the parties for the disposal of that preliminary issue and give a quietus to the suit and pronounce the judgment on the preliminary issue alone. And such framing of issues need not concentrate on framing of other issues. It can decide that issues first and make the party to lead evidence on that aspect alone and give a judgment. See, when the words are used in Order 14 Rule 1 that court has to pronounce its judgment on all issues, read with Order 20, even Order 20, if you are going to look into Order 20 Rule 5, it specifically says the court is having a mandate to decide all the issues, but with a caution, it states that in suits in which issues have been framed, the court shall state its finding or decision with reasons thereof upon each separate issues. Unless, the words are very important, unless the finding upon any one or more of the issue is sufficient for decision of the suit. These wordings are to be read along with the power of framing a preliminary issue under Order 14 Rule 2 subclass 2 regarding the jurisdiction and the bar, and if the court decides giving an adjudication and giving a decision on these issues will leads to the decision in the main suit itself, then the judgment can be to that point alone. And that is how the change under Order 14, Rule 2 has happened after amendment. And that is how, even though the civil court is having a complete mandate to pronounce judgment on all issues, when we read Order 14, Rule 2, subclass 2, read with Order 20, Rule 5, and also another important provision is Order 15, Rule 3, what are all the issues between the parties? These three provisions are read together. The importance of the right of the defendant to raise an issue of law as a preliminary issue and get the suit disposed on that issue itself is a vital right given to the defendant at the time of settlement of issues. Therefore, whenever we appearing for the defendant, my dear friends, we have to look into the plaint averments, and we have to look into the technical aspect, which will not take us to a complete trial. And for that, the importance of Order 14, Rule 2, and the provisions under other special enactment, and the right given under Order Section 12 of the Court Fees Act, along with Order 15, Rule 3, and Order 20, Rule 5. These are all the provisions which is very important before you put your pen down to write your written statement. Therefore, these provisions gives a very important right to the defendant, and such right are to be exercised very carefully. And these rights given to the defendant and the CPC will get a quick disposal of many suits which we are missing nowadays. And with this note, now I am rounding up my discussion or my lecture, and my friend can go on with the questionnaire sections if any. Thank you, and I thank everyone here who are here to share their Saturday evening hours with me. And I believe I have shared some important points within this allotted time, and it will be helpful for you. And any queries, please.
Just checking out any questions. Mr. Devesh is asking, sir, do you have any case laws on res judicata as preliminary issue?
No, definitely. My opinion is, my brother, if you raise res judicata as a point of defense to say it is a bar under statute by 11 of CPC, it is my humble opinion, it cannot be tried as a preliminary issue, because doctrine of res judicata can be decided with evidence, and there must be some adjudication of previous litigation, pleadings, issues, and judgments. Therefore, my opinion is, if you raise a suit is barred by res judicata, it cannot be decided under Order 14, Rule 2.
This is by Manju on the YouTube, since we are live on the YouTube also. Manju says, can limitation be a preliminary issue?
Yes, that is my answer is, if from the pleadings of the parties, that is both plaint and the written statement, if you can say that the suit is barred by limitation, very evident from the pleadings, then it can be taken. But what is the thumb rule? We are taking that question of limitation. Objections regarding limitation aspect are all mixed question of fact and law. And if it becomes a mixed question of fact and law, you must see the objection regarding a preliminary issue must be very evident. If you are going to search for evidence, if you are going to read some papers and get evidence to show that it is barred by limitation, then definitely it cannot be a preliminary issue. Therefore, my answer to my sister is, the limitation aspect, always it is a question of fact and law. It is not an issue of law. Only in rare cases it becomes an issue of law.
This is by Kerala anyway. Can we file an application under Section 151, read with Order 14, Rule 2, to remove the self-acquired properties in the partition suit especially when the owners are still alive and the suit is undervalued?
Yes, number one, these issues, either as preliminary issues or as a issue to be decided under Order 7, Rule 11, is a rejection or a disposal of a suit as a whole. If you want to remove the self-acquired properties from a plaintiff, then it has to be decided as an issue in the suit. The result may be excluding those properties, you can get a relief, but it cannot result in a disposal of a suit. Order 14, Rule 2 specifically says a disposal of a suit on a preliminary issue. Therefore, removing a self-acquired properties from a suit for partition will not result in a disposal of a suit. Therefore, that cannot be tried under Order 14 Rule.
This is by Ariva Anubu. She acknowledges you. You are a knowledgeable personality.
Thank you.
Anil Sharma Batra says, can a defendant participate in the final arguments before the judgment when he has not given any evidence and none of the other litigants, mainly the plaintiff and other defendants, has not come to cross-examine him?
Yes, of course, you are entitled to argue only on the materials available on record. You cannot travel beyond the materials available before the court. If you have not poured into any evidence inside the court at the time of trial, even why the ex parte evidence are taken. Now I will come to this point. A defendant was sent ex parte. The court is not pronouncing judgment immediately. It goes for an ex parte evidence. Then you can enter that court at that point of time and you can cross-examine the plaintiff without any pleadings or without supplying any documents. You are entitled to argue with the available evidence and available records without supplying anything, even at the final hearing stage, final argument stage.
So, thank you, Mr. Meenakshi, for sharing your knowledge.
Thank you. I'm also very glad to be there in this platform.
Yeah. Rather, I was feeling that the topic should have been practical aspects or practical tips for the preliminary decree.
Yes.
Okay. This is the last question. How the valuation of the suit can be decided as a preliminary issue by a roving inquiry or any other ways?
Yes. First of all, to my all friends, to decide a preliminary issue, there can be a summary inquiry with some evidences. It cannot be stretched to a roving inquiry. So even if a valuation point is taken as a defense to frame it as a preliminary issue will be framed. You will assist the court with materials. That materials must be amounts to a summary inquiry to come to a decision that valuation is wrong. Or if it needs a roving inquiry to lead a very big oral evidences and a cross-examination, then I must say in other words, by running you must find a fault. On your running, not even walking, on your running you must find that fault, that it is not correctly valued. If you sit, examine, read, and then find it is not correct, it is not a preliminary issue.
Okay, thank you. So I would say that the topic is preliminary issue, but it is not preliminary, but you have given a holistic view.
Yeah.
Thank you, everyone. Stay safe. Stay blessed.
Thank you.
Tomorrow we understand the procedural aspects of electronic evidence in the new act by Mr. Yuvraj Navrankar. He has also written a book, and a lot of his sessions are doing well. So do stay connected with us at 6 p.m. tomorrow.